what every Social Security disability applicant with deep vein thrombosis or its complications needs to know about steps 4 and 5 of the 5-step sequential evaluation. If you don't meet a listing at step 3, you will have to prove at step 4 that you can't go back to the lightest job you held in the 15 years before you became disabled, and at step 5, that there isn't any other work that you can do in the mythical national economy based on your age, education, skills, and your residual functional capacity. Well, what on earth is that? Your residual functional capacity is what you can do despite your deep vein thrombosis or its complications. Many times, claims for Social Security benefits are denied at the initial stage in the request for reconsideration stage because the Social Security Administration just can't figure out whether you can do sedentary work, light work, medium work, or heavy work. If your records are silent, your doctor hasn't commented or hasn't completed what's called a residual functional capacity form, the Social Security Administration will send your file to a medical consultant. And guess what? They'll opine that you can do a level of work that will result in a claims denial. The reality is, the lower your residual functional capacity is, the more likely it is you'll get your benefits. The Social Security Administration won't tell you about the existence and importance of a properly completed residual functional capacity form. But I have, and you need to have a form that's completed by your doctor that will explain how far you can walk, how long you can stand and sit at one time and in an 8-hour day, how much you can lift, stoop, squat, and bend during an 8-hour day, whether or not you have to alternate sitting and standing, whether you've got to elevate your feet, and if so, for how long and how often, whether you have problems with fatigue and concentration because of the problems that you're having with pain, or whether you have problems with balance because of the swelling in your legs, whether you have problems with your feet that make it difficult to walk, operate machinery, go up and down stairs, whether you have difficulty starting something and staying on task because of your pain, you need to go to the bathroom, you need to elevate your feet, whether you have good days and bad days, how many days per month you've missed from work, whether you have psychological problems like depression or anxiety that would interfere with your ability to work. This is not an exhaustive list of the questions that are on a deep vein thrombosis or other applicable residual functional capacity form. But hopefully you can see having an explanation of what you can do physically and cognitively and emotionally is the key to winning your case. It's 50% of the key, if you will. Many cases are lost because the applicant doesn't get a form, doesn't get the right form, their doctor doesn't fill it out properly, or the doctor says, don't bother me with that form. These are some of the reasons why you should have an experienced Social Security disability attorney such as myself represent you. But just as important as getting that residual functional capacity form is addressing the vocational aspects of steps 4 and 5. If the Social Security Administration can't figure out what you can do, they certainly aren't going to be able to award you your benefits because they'll default and say you can go back to the lightest job you held in the 15 years before you became disabled, and you can do other work in the national economy. That means that 2/3 of the time, claims at the initial application or request for reconsideration stage are denied. And that means you're going to end up in front of a judge in a trial. Now, at the trial, the judge will determine your residual functional capacity, and they're going to give a hypothetical to the vocational evaluator, who will be testifying about steps 4 and 5. So the judge may give a hypothetical like the following. Mr. and Mrs. VE, I want you to assume that this mythical person, just like the person in this hearing room, can sit for 6 hours and stand for 6 hours and walk for 2 and lift 10 pounds. Can they go back to the lightest job they held in the 15 years before they became disabled? That's a crappy hypothetical, and it's one that will lead the VE to say, oh yes, Judge, they can go back to the lightest job they held in the 15 years before they became disabled. And you know what that means? A claims denial. If the judge doesn't add anything to the hypothetical, or there isn't a lawyer like myself to add anything to the hypothetical, you're going to lose. The judge should go on to step 5. If the vocational evaluator says, no, the person can go back to the lightest work they did, Your Honor. The next question is there any other work in the national economy in view of the age, education, and skill level, and that residual functional capacity that I just gave you? Now, that example that I just gave you will result in the VE saying, oh yes, Judge, the applicant could put silverware in a cloth napkin and roll it up all day. They could sit in a laundromat and fold laundry, or they could address envelopes all day. If if the judge doesn't add anything that's relevant to that hypothetical, like the need to elevate legs or the need to take a break or the need to take a nap or being off task more than 20% of the time, you will lose. I hope that you now understand why it's important that you have an attorney represent you at all stages of the claim. Many times applicants just do a lousy job of describing their occupational duties and they don't get a residual functional capacity form, and that means there's a claims denial. And they make the same mistake again at the request for reconsideration stage. 2 strikes. The odds of getting your benefits are greater at all of the stages of a Social Security claim when you're represented by an experienced Social Security disability attorney. You owe it to yourself and your family to get help. Call me today at 727-894-3188 for a complimentary consultation. Make the call. Cavey Law.